Welcome back, everyone, and thank you for tuning into today's video. Some time ago, I covered a sovereign citizen case that gained widespread attention because of its bizarre courtroom exchanges and unusual claims. Since then, many viewers have been eager to hear any new information, and now there are finally fresh updates to discuss. The recent developments have made the case even more unexpected, revealing details that very few people anticipated. If the earlier incidents already seemed unbelievable, this latest update pushes the story even further and offers
the record. I am the beneficiary of the Frank Anthony Michaud Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee, ma'am.
Toward the conclusion of the last video, Judge Martin mentioned that the defendant's upcoming hearing would be handled by Judge Oakley. Some viewers may already recognize that name from earlier videos on this channel. Judge Oakley has built a reputation for maintaining firm order in his courtroom and ensuring that proceedings remain professional and organized. He is known for expecting direct responses, respectful conduct, and full compliance with courtroom rules. For that reason, many people were curious to see how the next stage of the case would unfold once it was brought before him.
The barcode, though, this is what you signed up to do. You're a public servant.
Unless you are a price on a can of beans, we don't need a barcode.
Today marks the moment many people have been anticipating, and the events inside the courtroom became even more intense than expected. The hearing rapidly turned into one of the most unforgettable courtroom encounters featured on this channel. Judge Oakley remained composed, assertive, and completely committed to maintaining control during the proceedings. Right from the start, the mood in the courtroom was serious, and the interaction between the judge and the defendant led to several uncomfortable and unexpected exchanges. As the session moved forward, it was obvious that the case was heading in a highly unpredictable direction.
All right, appearances for the people versus Frank Michaud Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not. You have works. So
yeah,
you're on the side here.
Are you up? Please sit at the desk representing yourself.
The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to...
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
One detail many viewers immediately notice about Judge Oakley is his straightforward and disciplined style during courtroom proceedings. He values direct communication, keeps discussion centered on the matter at hand, and avoids wasting time on unnecessary interruptions. During this case, his steady yet authoritative manner became one of the most discussed aspects of the hearing. As the video goes on, the courtroom atmosphere grows even more intense, featuring unexpected interactions and mounting tension from beginning to end. By the conclusion of the hearing, there is a great deal for viewers to reflect on regarding how the entire situation developed inside the courtroom.
If I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on. Are you picking him up? That's one of the reasons I want you up here is there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You have
I took an oath that said I would follow the Constitution.
to not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding your oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have...
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights as
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
May
All
I?
right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make. And that, you know, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, you know, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
At this stage, a lot of viewers had already started to question the defendant's decisions as the case progressed. One of the most unexpected aspects was the choice to move forward in such a serious legal matter without hiring a professional attorney. Even though trained legal experts are specifically prepared for situations like this, court processes, legal standards, and criminal proceedings can become highly complex very quickly, which is why many individuals typically depend on qualified lawyers for support. As the hearing went on, that choice drew even more attention, as several courtroom moments highlighted just how challenging it can be to represent oneself effectively.
Okay.
So, with that being said,
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
so today,
You have a jurisdictional argument you want to make?
well, I served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
Yes or
multiple-
no?
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your
Okay,
jurisdictional
so
argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that,
I work
Criminal
under the authority
or
of the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty,
What
and
is it?
it's not common law.
Which
It's
one?
statutory.
Okay, so it's statutory, that is what, civil?
No,
So what is it? For the
my
record, I need to
jurisdiction is
have-
both
I
civil.
can't defend myself unless I have it on the record.
Situations like this often highlight how crucial it is to have a solid understanding of courtroom procedures before attempting to represent oneself. In legal systems, courts generally operate under established statutory and common law frameworks, while other terms that people sometimes mention in online discussions can be misunderstood or taken out of context. Without a clear grasp of how actual legal rules and procedures function, arguments in court can quickly become confusing and difficult to present effectively. During this hearing in particular, several moments illustrated just how complex proceedings can become when a case is handled without professional legal guidance or a strong
As provided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes,
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
there must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I injure
are bringing the
the state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I'm saying,
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat, wow.
You're probably going to hear more than one.
I see.
From the judge's response, it was evident that patience in the courtroom was beginning to run low. The hearing grew progressively more strained as interruptions and back-and-forth exchanges continued during the proceedings. At multiple moments, the judge seemed intent on re-establishing order and ensuring the case proceeded in a controlled and orderly manner. Many viewers believed the situation might have unfolded more smoothly if the defendant had spoken less and adhered more closely to the court's directions. As the interaction went on, the overall tone in the courtroom became increasingly serious and hard.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
she's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness, yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100.
Nice.
Many viewers respect judges like Judge Oakley for the way they maintain structure, focus, and decorum during courtroom proceedings. Throughout this hearing, he stayed composed, straightforward, and dedicated to keeping everything moving efficiently without unnecessary interruptions or delays. His professional demeanor was especially noticeable during several tense exchanges, when the discussion became harder to control. By the conclusion of the session, it was easy to understand why many people view him as someone who approaches his judicial responsibilities with a strong...
Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people call Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here it
This
says,
is the probable cause hearing.
it says,
All right, stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied? Not
because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objection to the evidence.
That we are having a preliminary exam when I haven't had a probable cause hearing that I did not.
They're the same thing, Mr. Michaud.
It's still on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate?
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
Understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it?
That reflects what many people expect from effective courtroom management: clear authority, consistent direction, and a focus on keeping proceedings orderly and respectful. The judge's handling of the situation demonstrated professionalism and helped make the process easier to follow as it unfolded. Courtrooms function most efficiently when structure is maintained, and participants are guided step by step through the case without unnecessary confusion or delays. A well-organized approach like this contributes to greater clarity and smoother proceedings overall.
Because if this is a hearing, or
you didn't
right,
waive it.
so
There's nothing to hold.
Do I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he gets to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, you ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
bid bond.
Hold on.
I requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
okay, listen. You can't tell me something and then just disagree with me and think. Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay, that's just the way it works. My courtroom, I get to decide how it's run.
There's a key distinction that clears up the apparent contradiction. Courts don't operate on whether an instruction feels meaningful or valid to a participant. They operate on legal authority and procedure. Even if someone believes an order or rule is incorrect or baseless, it still has to be followed in the moment because the court has the power to enforce compliance. Disagreeing with a ruling is allowed in a legal system, but the correct way to challenge it is through formal channels, like objections on the record or appeals afterward, not by ignoring it during proceedings. So compliance in court doesn't necessarily signal agreement or recognition of correctness. It more often reflects awareness that. That's why courtroom procedure is structured the way it is. It prioritizes order and resolution in real time, while still leaving space to.
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone here has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent a affidavit of fee schedule for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice, and
great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice. Okay. Also, I served you notice on my power of attorney.
Okay, you said that.
Right, and
move on.
You haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't recognize any of that.
United States citizen. I am actually identified.
Stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does mean, hold on. It does, it should mean something because.
Prove it, please prove it.
Can I prove what?
Prove that I am not the artificial person.
I can prove you're Frank Michaud.
I have full faith and credit.
I can prove.
Okay, so.
Hold on, you've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here. And you proved it for me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing.
At this point, it almost seems like there's a clash between assumption and reality, especially given the serious nature of what's at stake. On one side is the tendency to rely on personal interpretation or belief, and on the other is the actual courtroom process, which is governed by established legal rules and procedures. In most legal matters, outcomes are determined by facts and applicable law rather than individual opinions or expectations. As the video wraps up, the judge continues with important comments that further clarify how the case is being managed. This final explanation helps the audience better understand.
Okay. But you're still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
listen to me. Mr. Michaud, I've wasted too much time with you. Yes or no?
So,
sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
That brings today's video to a close, but the case itself is still ongoing. Due to repeated interruptions and disruptive conduct, the probable cause hearing was not able to reach completion. As a result, another court appearance before Judge Oakley is expected, along with the possibility of further updates as the situation develops. If you found this video helpful or interesting, you can like it, and if not, you're free to dislike it and share your thoughts in the comments below. Don't forget to subscribe and enable notifications so you stay updated on future developments. I'll see you in the next update.